Thank you for pressing play. Your presence here brings joy to my heart. Welcome, curious minds, to our video that explores the ins and outs of European labour law. European labour law regulates basic transnational standards of employment and partnership at work in the European Union and countries adhering to the European Convention on Human Rights. In setting regulatory floors to competition for job-creating investment within the Union, and in promoting a degree of employee consultation in the workplace, European labour law is viewed as a pillar of the European social model. Despite wide variation in employment protection and related welfare provision between member states, a contrast is typically drawn with conditions in the United States. The European Union, under the Treaty on the Functioning of the European Union, Article is able to use the ordinary legislation procedure on a list of labour law fields. This notably excludes wage regulation and collective bargaining. Four main fields of EU regulation of labour rights include 1. Individual labour rights, 2. Anti-discrimination regulations, 3. Rights to information, consultation, and participation at work, and 4. Rights to job security. In virtually all cases, the EU follows the principle that member states can always create rights more beneficial to workers. The fundamental principle of labour law is that employees' unequal bargaining power justifies substitution of rules in property and contract with positive social rights so that people may earn a living to fully participate in a democratic society. The EU's competencies generally follow principles codified in the Community Charter of the Fundamental Social Rights of Workers 1989, introduced in the Social Chapter of the Treaty of Maastricht. Let's transition to history and uncover its significance. While free movement of workers was central to the first European Economic Community Agreement, the development of European labour law has been a gradual process. Originally, the Olin Report of 1956 recommended that labour standards did not need to be harmonised, although a general principle of anti-discrimination between men and women was included in the early treaties. Increasingly, the absence of labour rights was seen as inadequate given the capacity for a race to the bottom in international trade if corporations can shift jobs and production to countries with low wages. The Treaty on the Functioning of the European Union, deriving from the Treaty of Lisbon, lists in Article the European Union's competence in the field of labour law. What is conspicuously not included is unjust dismissal of workers, and according to Article Pay, the right of association, the right to strike or the right to impose lockouts. As it says, the Union shall support and complement the activities of the member states in the following fields. The objectives draw, according to TFEU Article 151, inspiration from a number of other treaties and sources, which in turn draw inspiration from the International Labour Organization and the Versailles Treaty. Let's now zoom in on labour and human rights and uncover the hidden gems that lie within. A first group of directives create a range of individual rights in EU employment relationships. The objective of transnational regulation is to progressively raise the minimum floor in line with Economic Development European Convention on Human Rights Articles 4, 6, 9, 10 and 11 European Social Charter 1961 Community Charter of the Fundamental Social Rights of Workers 1989. As we venture forward, let's examine employment contracts in detail and gain a deeper appreciation for its significance. The Employment Information Directive 2019 requires that every employee, however defined by member state law, has the right to a written statement of their employment contract. The consistent jurisprudence of the European Court of Justice is that an employee is generally to be defined according to the fact that he or she is invariably the weaker party in an employment contract and works under the direction of another. Laurie Bloom v. Landbaden-Württemberg 1986 c. The essential feature of an employment relationship is that for a certain period of time a person performs services for and under the direction of another person in return for which he receives remuneration. Pfeiffer v. Duches Roads Cruise 2005 c. The worker must be regarded as the weaker party to the employment contract, and it is therefore necessary to prevent the employer being in a position to disregard the intentions of the other party to the contract or to impose on that party a restriction of his rights without him having expressly given his consent in that regard. Danosa v. LK SI 2010 C. Holterman für Exploitative VV Spies von Boleschan 2015 C. The European Court of Justice expressly rules that there are generally no exemptions from the term employee for executives under European law, which would allow member states to restrict employee protection on non-executive employees. Platform Work Directive has been proposed to recognize platforms as employers and regulate algorithmic management. With our curiosity piqued, let's embark on a dedicated exploration of free movement and its fascinating intricacies. Articles state that workers have the right to move freely and work anywhere in the EU, without discrimination on grounds of nationality, subject to exceptions to preserve public policy, security and health. The Citizens' Rights Directive (IC). There is also an old directive concerning posted workers which has recently become highly contentious given decisions by the ECJ in the Rosella and Laval Posted Workers Directive (IC). As we progress, let's shine a spotlight on working time and childcare and examine its intricate interplay within our topic. Reflecting basic standards in the Universal Declaration of Human Rights and ILO conventions, the Working Time Directive 2003 requires a minimum of 4 weeks totaling 28 days paid holidays each year, a minimum of 20-minute paid rest breaks for 6-hour work shifts, limits on night work or time spent on dangerous work, and a maximum 48-hour working week unless a worker individually consents. The Parental Leave Directive 2019 creates a bare minimum of 4 months of parental leave to be used by parents' legal guardians and to be taken before the child reaches a specified age, up to the age of 8. As determined by each member state, of which at least 2 months are non-transferable and are paid at a level that is determined by the member state. 10 days of paternity leave paid at least at the level of sick pay, 5 days crow's leave, and the Pregnant Workers Directive 1992 creates a right for mothers to a minimum of 14 weeks paid leave to care for children. Working Time Directive (IC), Pregnant Workers Directive (IC), Parental Leave Directive 2019. In this chapter, we'll be unraveling the enigma of health and safety and discovering its transformative power. The Safety and Health at Work Directive 1989 requires basic requirements to prevent and insure against workplace risks, with employee consultation and participation, and this is complemented by specialist directives ranging from work equipment to dangerous industries. In almost all cases, all member states go significantly beyond this minimum health and safety of atypical workers. Directive 1991 (IC), Minimum Workplace Safety Directive 1989 (IC). As we progress, let's zoom in on pensions and examine its role in shaping our overall narrative. While there is no wage regulation, the Institutions for Occupational Retirement Provision Directive 2003 requires that pension benefits are protected through a national insurance fund, that information is provided to beneficiaries, and minimum standards of governance are observed. These include protecting the pension promise of employers in the event of business trouble, and require minimum standards of funding. Most member states go far beyond these requirements, particularly by requiring a vote for employees in who manages their money. Insolvency Protection Directive (IC), Article 8, Robbins v. Secretary of State for Work and Pensions 2007 C. The member state pension guarantee institution must reimburse at much more than 20% of pension. During the financial crisis, the EU created a network of transnational financial regulators in an attempt to prevent the undercutting of standards by countries competing on low regulation. One of these is the European Insurance and Occupational Pensions Authority, which replaced a committee known as the Committee of European Insurance and Occupational Pensions Supervisors. European Insurance and Occupational Pensions Authority regulation. The tax law for cross-border worker UE and extra UE is regulated by the Directive N. Let's now turn our attention to Social Security and uncover the fascinating insights it brings to the table. Equal treatment in Occupational Social Security Directive. Equal treatment in Social Security Directive (IEC), Social Security Regulation (IEC), and the IEC Directive (IEC). With our curiosity piqued, let's embark on a dedicated exploration of public procurement and its fascinating intricacies. Public Contracts Directive 2014 IU Arts 18, 6971 and Annex X Regia Postcomp and Covey Stadtlandau in Dub Files 2015 C. Prepare yourself for an eye-opening discussion on collective representation in the upcoming portion of this video. The EU is formally not enabled to legislate on collective bargaining, although the EU, with all member states, is bound by the jurisprudence of the European Court of Human Rights on freedom of association. Prepare yourself for an eye-opening discussion on participatory governance in the upcoming portion of this video. If a company transforms from a member state corporation to incorporate under the European Company Regulation 2001, employees are entitled to no less favorable representation than under the member state's existing board participation laws. This is practically important as a majority of EU member states require employee representation on company boards. Employee Involvement Directive (IC) European Company Regulation. With the groundwork laid, let's now examine information and consultation and its connections to our previous discussions. The Information and Consultation Directive 2002 requires that workplaces with over 20 or 50 staff have the right to set up elected work councils with a range of binding rights. The European Works Council Directive 2009 enables work councils transnationally, and the Employee Involvement Directive 2001 requires representation of workers on company boards in some European companies. In total, the requirement to inform and consult the workforce, negotiate with a view to agreement, is found in 4 directives: European Works Council Directive (IC) Art Information and Consultation Directive (IC) Art Business Transfers Directive (IC) Art 7 Collective Redundancies Directive (IC) Art 2. As we move forward, let's uncover the untold stories and fascinating intricacies of collective bargaining. Theoretically, only the European Court of Human Rights should have competence to decide issues related to collective bargaining and industrial action, as the European Union treaties do not confer competence on the EU to legislate on such issues. The scope extends to collective bargaining given the right to freedom of association under Article 11. In Wilson and Palmer v United Kingdom, the court held that any detriment for membership of a trade union was incompatible with Article 11. And in Demir and Baker v Turkey, the court held the right to bargain collectively with the employer has, in principle, become one of the essential elements of Article 11. This approach, which includes affirmation of the fundamental right to strike in all democratic member states, has been seen as lying in tension with some of the Court of Justice's previous case law, notably ITWF v Viking Line ABP and Laval and Partneri Limited v Svenska Byggnadsarbetareförbundet. These decisions suggested the fundamental right of workers to take collective action was subordinate to business freedom to establish and provide service. Article 11 ECHR Wilson and Palmer v United Kingdom, Demir and Baker v Turkey ECHR 1345 Erzberger v TUI AG 2017 C. Scope of free movement of workers, the Rosella IRLR 143 C. On freedom of establishment, Laval and Partneri Limited v Svenska Byggnadsarbetareförbundet IRLR 160 C. See also C. On free movement of service, collective bargaining and wage directive come final. With the foundation laid, let's embark on a journey into equality. Beyond the general principle of equality in EU law, 6 main directives protect basic equality rights in EU law. The rules are not consolidated, and on gender pay potentially limited in not enabling a hypothetical comparator or comparators in outsourced business. Equality rules do not yet apply to child care rights, which only give women substantial time off, and consequently hinder equality in men and women caring for children after birth and pursuing their careers. Without wasting any more time, let's jump into the fascinating world of general principle. The principle of equality regardless of status is a fundamental value in all European member states, and constitutes a core principle that pervades the objectives of every institution. Equality was affirmed by the Court of Justice in Czechowicz v. Swidixcomb and Co. KG to be a general principle of EU law Czechowicz v. Swidixcomb and Co. KG 2010c. This is reflected in a number of TFEU provisions. Article 8x Article TC. In all its activities, the Union shall aim to eliminate inequalities and to promote equality between men and women. Article 10. In defining and implementing its policies and activities, the Union shall aim to combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age or sexual orientation. With our foundation established, it's time to explore protected grounds and its relevance to our overarching theme. The Race Equality Directive 2000, Equality Framework Directive 2000 and Equal Treatment Directive 2006 prohibit discrimination based on sexual orientation, disability, religion or belief, age, race and gender. As well as direct discrimination, there is a prohibition on indirect discrimination where employers apply a neutral rule to everybody, but this has a disproportionate impact on the protected group. Equality Framework Directive (EIC), Race Equality Directive (EIC), Equal Treatment Directive (EIC). In this section, we'll be shedding light on atypical workers and its impact on our understanding of the subject. The Part-Time Work Directive 1997, Fixed-Term Work Directive 1999 and Temporary Agency Work Directive 2008 generally require that people who do not have ordinary full-time, permanent contracts are treated no less favorably than their colleagues. However, the scope of the protected worker is left to member state law, and the TAWD 2008 only applies to basic working conditions, mostly pay, working hours and participation rights, and enabled member states to have a qualifying Part-Time Workers Directive (EIC), Fixed-Term Work Directive (EIC), Temporary and Agency Work Directive (EIC). Moving on to the next segment, we have job security. Minimum job security rights are provided by 3 directives. There are further norms in the treaties which aspire to create a high level of employment in the EU. Brace yourselves for the next chapter, where we'll be dissecting business restructuring. The Collective Redundancies Directive 1998 specifies that minimum periods of notice and consultation occur if more than a set number of jobs in a workplace are at risk. The Transfers of Undertakings Directive 2001 require that staff retain all contractual rights unless there is an independent economic, technical or organizational reason, if their workplace is sold from one company to another. Last, the Insolvency Protection Directive 2008 requires that employees' wage claims are protected in the event that their employer falls insolvent. This last directive gave rise to Frankovich v. Italy, where the Court of Justice affirmed that member states which fail to implement the minimum standards in EU directives are liable to pay compensation to employees who should have rights under Thumjunk v. Knoll 2005c. The Collective Redundancies Directive 1998 imposes an obligation to negotiate. USD/WVWW Realization 1 Limited 2015c, 5th Chamber. Brace yourself for a deep dive into unemployment as we explore its impact and relevance in our evolving narrative. Today, the EU is required under TFEU Article 147 to contribute to a high level of employment by encouraging cooperation between member states. This has not resulted in legislation, which usually requires taxation and fiscal stimulus for significant change, while the European Central Bank's monetary policy has been acutely controversial during the Eurozone crisis. The EU undertakes ad hoc initiatives to combat unemployment, but only indirectly through better regulation. It does not have any specific fiscal stimulus program outside funds used for general regional development for Article 9. In defining and implementing its policies and activities, the Union shall take into account requirements linked to the promotion of a high level of employment, the guarantee of adequate social protection, the fight against social exclusion, and a high level of education, training and protection of human health. articles on coordinated strategies to promote employment. European Union Labour Force Survey, Eurostat, European debt crisis post-2008, Irish economic downturn, Greek government debt crisis, Spanish financial crisis, Portuguese financial crisis. With the groundwork laid, let's now examine gig economy legislation and its connections to our previous discussions. In December 2021, the European Commission published new draft legislation to ensure gig workers get a minimum wage, access to sick pay, holidays, and general employment rights. The announcement sent stock prices of gig economy brands lower, including Deliveroo, Just Eat Takeaway, Delivery Hero. Don't forget to check out my other videos for more valuable content.